attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the federal and Florida M&A Broker exemption. Following the SEC's lead, effective July 1, 2016, Florida passed a statutory exemption from the broker-dealer registration requirements for individuals and entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. A plain reading of the federal and Florida broker-dealer exemptions for M&A brokers would allow a non-registered broker to perform services and collect a fee for a reverse or forward merger transaction with a non-shell company that is either completely private or that is alternatively reporting on the OTC Pink or OTCQX tiers. The Florida statute does not refer to the federal definition of a public shell company, but rather provides its own definition. The Florida M&A Broker exemption defines a public shell company as a company that, at the time of a transaction with an eligible privately held company, has any class of securities which is registered or which is required to be registered with the SEC under the Securities Exchange Act of 1934, or for which the company files or is required to file periodic reports under the Exchange Act, has nominal or no operations, and has nominal or no assets or assets consisting solely of cash and cash equivalents. Accordingly, the Florida definition of public shell company does not include public companies that do not file reports with the SEC, such as companies that trade on and alternatively report to the OTC Pink or OTCQX tiers of OTC Markets. The federal definition of a shell company, at least the definition in Rule 144, does not limit the company to one that has a class of securities registered under the Exchange Act or that is required to or files reports with the SEC. The federal definition of a shell company in Rule 144 includes any issuer of securities. Since both the federal and state broker registration exemption must be satisfied in order to proceed, completing a transaction with any shell company would be problematic for a non-registered broker. However, completing a transaction with a non-reporting, non-shell company and collecting a fee as an M&A broker is not difficult and is clearly allowed. The requirement that the transaction not be registered or required to be registered is also easily met. The vast majority of reverse mergers and forward acquisitions are completed using an exemption from registration, such as under Rule 506. Furthermore, it appears that Florida is actually contemplating reverse mergers and forward acquisition transactions with public companies by specifically addressing exchange offers and requiring certain financial information and statements and certain disclosure documents in an exchange offer. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.